In this video, I'm going to reveal 10 proven strategies that could get your stunt driving charge in Ontario potentially dismissed or reduced. Even if you think you're guilty, these legal tactics might save you from severe penalties. So what are these strategies? Let's get started. Firstly, what exactly is stunt driving in Ontario? According to Section 172 of the Ontario Highway Traffic Act, it includes driving 40 kilometers or more over the speed limit where the speed limit is less than 80 kilometers, or driving more than 50 kilometers over the limit where the speed limit is 80 kilometers or more. It also covers racing, performing stunts like drifting, and even driving with someone in the trunk. Now, why should you care about beating this charge? Because the penalties are so incredibly harsh. We're talking about an immediate license suspension. We're talking about vehicle impoundment, hefty fines up to $10,000, even potential jail time. So what's the first strategy to beat a stunt driving charge? It's all about challenging the evidence. This means questioning the accuracy of speed measurement devices. In a recent Toronto case, a driver beat the charge by challenging the reliability of the automated speed camera. Now, when cross-examined, the prosecution, they couldn't prove the camera's accuracy, and the charge was actually dismissed. But what if the evidence seems solid? Well, that's where our second strategy comes in. That is proving necessity or duress. If you were rushing someone to the hospital in an emergency, you might argue that exceeding the speed limit was necessary to save someone's life. Now, you might be wondering, what if it's the officer's word against mine? Well, that leads us to strategy number 3, which is disputing the officer's observations. Poor weather conditions or limited visibility can cast doubt on their ability to accurately assess the situation. But what if you were accused of racing or performing stunts? Strategy 4 is arguing lack of intent. Maybe you were just accelerating to merge onto a highway with no intention of racing. Now, here's something most people don't know. Strategy 5 involves charter right violations. If your rights under the Canadian Charter of Rights and Freedoms were violated during the stop or the arrest, you might be able to have the evidence excluded. What if none of these strategies seem to fit your case? Well, don't worry, we are only halfway through. Strategy 6 is negotiating a plea bargain. While not technically beating the charge, it can result in reduced penalties or a lesser charge. Strategy 7 might surprise you. It's actually about challenging the jurisdiction. In some cases, you might be able to argue that the court lacks the power to hear your case. For strategy 8, we have the defense of due diligence. This actually involves showing you all the reasonable precautions were taken to avoid committing the offense. For example, you might argue that you were relying on a recently calibrated speedometer. Strategy 9 focuses on technical errors in the charge. Sometimes stunt driving charges can be dismissed due to errors in the paperwork, like an incorrect date or location on the summons. Finally, strategy 10, and perhaps the most proven way to beat a stunt driving charge, hire an experienced representative. They can identify weaknesses in the prosecution's case, negotiate with prosecutors, and present compelling arguments in court. Remember, beating a stunt driving charge in Ontario is challenging. It's not impossible. Each case is unique, and the best defense strategy depends on your specific situation. If you've been charged with stunt driving in Ontario and you want to know more about any of these strategies before you actually go to court on your own, let's book a meeting. Let's discuss the facts of your case. With the right approach and legal representation, you can potentially beat a stunt driving charge and avoid the severe consequences that come with a conviction.